Yeah, that's a great store.
Good store.
Yeah.
All right, we're live.
Some of those places that are.
Welcome back to the Judiciary Committee. And this afternoon, we are going to take a look at S33, and then we have some witnesses on S89. And I am hoping that we can pass S33 today, but we will see once we hear of any of the additional changes that we have. Over to you, Eric.
Yes. Good afternoon, everybody. Eric Fitzpatrick with the Office of Legislative Counsel to look at the latest possible committee amendment to S33, which is the miscellaneous judiciary bill. Does everybody have version 2.1 with today's date on it? 5.3?
Yes.
Thank you. So should we just look at, Representative Long, just the highlighted areas, the changes part, kind of review those? Does that make sense?
That's all. I think we reviewed the other stuff twice.
Yeah, I think you're right. Yep. So there's been a change in section 9 on page 6, and this is remember, this is the increase of the small claims limit. Currently, $5,000 is the threshold, the maximum amount that one can have in damages to bring an action in the small claims court. And the proposal is to increase that to $10,000 so that one could have $10,000 or less in damages and bring an action in small claims court. Remember, the committee discussed the concept of excluding a couple of types of actions from that. That's what the proposed language on line 6 does. Lines 14 to 18, you'll see takes two types of damage actions and excludes them. They would be actions for collection of any debt greater than $5,000. So in other words, less than $5,000 would still be okay in small claims court. But if it's greater than $5,000, then it involves either a consumer credit transaction, so that's a credit card type of transaction as defined under federal law, or a medical debt as defined elsewhere in Vermont law, which, as it happens, was just defined last year. And that is defined as, let's see if I can see. Medical debt means debt arising from the receipt of healthcare services. So fairly broad. Healthcare services means services for the diagnosis, prevention, treatment, cure, or relief of a physical, dental, behavioral, or mental health condition or substance use disorder, including procedures, products, devices, and medications. So pretty broad. So those would be excluded. If those were above 5,000, those would still have to be brought in the civil division of Superior.
Questions? I'm not seeing. Thank you. Oh, go ahead, Barbara.
Okay, so I just want to make sure what's not in there. So mortgage wouldn't be in there, or a car payment, other than if that was on a credit card. So if like somebody defaulted on their mortgage payment,
Right.
the mortgage company could not take them to small claims court. We're just carving out
Presumably that'd be larger than
what, 10,000?
No,
Wow.
maybe.
So also if they're seeking foreclosure, the
Right,
foreclosure
yeah.
procedures are in the Superior Court. So
Okay.
I don't believe there's foreclosure procedures in the small claims court.
So I'm kind of curious, when you added, Martin, when you added medical, that made me start thinking about other categories. And so I don't know if we can speak to why medical is in there. Is medical in there for a specific reason?
Testimony yesterday, Rachel Seelig mentioned that Mike Fisher was concerned as a
Okay.
healthcare advocate that an increase in 10,000 would be a problem for people who are facing medical debt because, sort of the tension here, of course, is that on the one hand, this does provide easier access to people to access the court system. They don't have to pay lawyers and all the expense of that. But then the downside of it is that the truncated procedures could potentially lead to a consumer being taken advantage of. And so
Yeah.
for these two areas, legal aid felt that was important to carve them out.
So we're not overlooking a category.
There haven't been testimony about any other
Yeah.
categories, but yeah.
Well, also, in what we got, which I thought was very helpful, the Connecticut, sort of
Right, yeah.
overview of other states did not mention any other categories. So,
Right.
I think that's, other people have done a lot of work looking at potential
Yeah.
things to do in this regard when updating these, and nothing else was mentioned.
All right, I think we're good.
That's great. Next, section 10, we did talk about this once before, I think already. Remember, this is the oath for jurors in criminal cases, the original change in the bill was just to update the language prisoner at the bar to defendant, but then also the committee noticed that the language swearing and specifically so help you God didn't include the option for affirmation under the pain and penalty of perjury, which we try to do these days, so generally updating statutes. And I saw that there may be some work able to do going forward on that as far as future instances where this might come up, because I'm sure, not sure, I suspect that there's other places in statutes where we haven't made the updated change as well, but at least this does so here, so that it provides the option of affirming under the penalty of perjury if one chooses not to swear.
So the top of page 7. Do you solemnly, that word, swear or affirm? So I mean,
You one or the other.
I understand that, but like, okay, so I decide to swear, like some smart, somebody that wanted to have fun with that would go and swear. You know what I'm saying?
It doesn't mean that it's not profanity.
No, I know that, but I wonder if they take it. So am I making something out of nothing?
Yes.
They wouldn't mess with that at all? Nope. Okay.
It's in other places.
Yeah, it's language that is, I think, been used very almost identical language for a few years now. And I've heard it read to people that way too. Like, do you solemnly swear or affirm?
It's also in our oath that we take at the beginning of the session.
It just seems like it's missing something.
Okay.
Means to bind oneself by oath.
I know, but the average person doesn't, it's like affirm, like what's affirm mean,
I think the circumstances around which it's being offered also tends to indicate that's an important thing.
Are you a lawyer?
I am. But just imagining, you're a juror and you're asked to raise your right hand and say, you solemnly swear or affirm, blah, 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 blah.
That's, hate to give you any credit, but that's a good way of looking at it.
All right, I think we're on page 23.
Yes, indeed. This is the provision requested by the Attorney General's office around making clear when the statute of limitations starts to run in environmental contamination claims. And this is just a little bit of a tweak to that language to do two things, actually. Make sure that it's clear that it doesn't apply to a criminal claim whose limitations period has already expired. So in other words, it's not going to revive a criminal matter that's already extinguished because it's past the statute of limitations time. And also to be clear that that this applies notwithstanding the general statutes on pending litigation and respective applications. So then we get to the new. So those several things were amendments to provisions that had passed the Senate. Starting on page 24 and starting on section 29, these are all new sections proposed to be added by the House. So that's why it's all highlighted. Everything is highlighted. So section 29 is and I will not remember the numbers of each of these bills, but that is a bill that I think the committee looked at and approved inclusion of regarding there's the current statute about sexual exploitation of a person in the custody of a law enforcement officer. And this adds to that prohibition, not only a person who's in custody, but also a person who is being investigated, detained, or arrested.
Page 22, if anyone is curious.
Thank you.
This right here?
What is that? Say this again?
Page 22.
Oh, right, page 22 is where I came from. Yeah.
Section 30 is, any questions on that section? Section 30 starts on page 25, line 15. This is the provision I think the committee also looked at that makes an exception for possession of tobacco products by persons under 21 if it's being used in connection with indigenous cultural tobacco practices. That's on line 2, top of page 26. That was also a separate bill. I want to say H-175, but I could be wrong on that.
Nope, that's H-250. No, H-250 is the next one. I don't remember.
Neither. We'll track that down.
Maybe H-212.
Angela knows.
Have a number.
Yeah, I don't.
It did,
I mean, we just brought up the
I think, thank you very much. It did not have a number.
I put question mark.
No, H-212.
212. Remember that?
Yeah.
So 31, section 31 is over page 26. This was also in a bill, is it 250?
Yes.
Page 250. And this is the truing up the consent for a blood test for drivers on the roads with the underlying DUI criminal offense language. So the underlying DUI prohibits being under the influence, driving and operating a vehicle under the influence not only of alcohol and not only of drugs, but also under the combined influence of alcohol and drugs. Whereas the blood test, you'll see under existing law, only allows blood test if the person is under influence of a drug other than alcohol. In other words, it doesn't have that other provision that is also in the DUI offense about the combined influence. So this allows the blood test in those situations as well. Section 32, top of page 27, this is the possession of a firearm in a hospital building. Language, there's a little bit of a slight tweak to the language here. And this is, remember, so this is the bill that you passed last year that generally prohibits possession of firearms in hospital buildings. There's an existing exception you see on line 27, lines 10, 13 for law enforcement officers. And this adds a few other exceptions, which I'll note are also in the New York statute that prohibits possession in hospitals. It has these same exceptions or similar. So the security guard or private investigator one you'll see in subdivision 2, line 14. The language added here is in line 15 on behalf of the hospital. I think that was at the request of the hospital association who was wanted to make sure that the private investigator or security guard were actually working on behalf of the hospital, not just sort of randomly in the hospitals doing some work on their own. But otherwise, it's the same as you saw last time. So they would also be exempt. They could carry, as long as they're working, they're performing their official duties on behalf of the hospital. Similar for corrections officers performing their official duties. That's line 3, page 27. If you turn over to page 28, other law enforcement officers from other states who are authorized by their own states, and National Guard and other military folks in subdivision 5. So they're all acting essentially in the scope of their official duties, then they are exempted and would be able to carry. These are new sections to the bill, but certainly not new sections to the committee, and they are sections 33, 34, and 35, which run from line 13 of page 28 all the way over to line 11 of page 29. And those are just cut and pasted from S4. So this is the extension of the Raise the Age Initiative for Juvenile Law 2024 and the related requirement that DCF give progress reports to the legislature in, I think, September and December on how they're doing as far as trying to meet that July 1st, 2024 implementation date. Section 36 was, I think, just discussed yesterday, and this was the issue of defendants in our relief from abuse orders, there being a requirement that even when a defendant is in court for the RFA proceeding, there's still a requirement that they be personally served with the order. And this is making clear that for defendants who have been there and received notice of the proceeding because they were physically or on Zoom, one or the other, present in court for purposes of the issuance of the order, then the order can be mailed to them rather than having to be personally served. If they weren't there or they didn't get a notice by being a participant in the hearing, then they would still have to be served. But if they were there, then they could rely on the mailing of the order. And lastly, the section 37, which is again another bill number that I'm not remembering off the top of my head. Thank you very much. This is an S27 with a slight modification, which I'll mention, but this is asking the Vermont Sentencing Commission to study and report on, and the way you see the language here is, you look at line 10, make a recommendation as to whether cash bail should be eliminated in Vermont. The way the language had been phrased in S27, it didn't include the option for the commission to decide whether or not it's a good idea. It just said, make a recommendation for eliminating cash bail. You know what I mean? It sort of assumed that that would be the recommendation. So this is modified a little bit, providing them the option to think that maybe it shouldn't be, whatever. They can make that recommendation either way, but then you see in the next sentence, if they propose to eliminate cash bail, it shall provide a proposal that does so. In the Senate version, it was just provide the proposal to eliminate cash bail. Didn't give them the option to decide that maybe that wouldn't be a good policy.
Ken, you have a question? You had that look that you had a question.
No, I was pondering. Thanks. But thank you for being genuinely concerned.
As I always am. Yes, Karen.
We were going to add Center for Crime Victim Services.
Oh, yeah.
This wasn't the place that we could certainly.
Oh, no, that's a different bill. It's a different bill. Yeah.
But I'm sure that Jim Pullman would appreciate if we did.
I don't know.
Karen
if
is
it's
kind of
necessary.
starting to wear off on you.
I know.
And me, I should add.
Too many bills.
It does get confusing.
But I feel like it's never bad to suggest that inclusion, so.
So is Crime Victim Services on the Sentencing
Yes,
Commission?
we are.
Yeah, they're on the Sentencing Commission. So,
Thank you. Perfect.
yeah, so we're good.
But we could add something.
Oh, here we go.
About crime victim.
Sorry.
services in this.
We have crime victims.
I don't mean in that section.
Looks great.
I think we're not adding anything else at this late point. Because I think very soon, well, we're going to move to other people right now, but hopefully, are folks going to be ready to vote for this? I'm assuming people don't want to go through this yet.
I do have one other question.
Oh, yeah, no, please ask me. Go ahead. Questions are good. Yes.
Subtraction is no addition.
Yeah, questions are good.
Crack statute, were we including that or no?
The which one?
The crack?
No.
The decision's been made.
No, it's just, I would need to make absolutely sure that that's not a trigger point for the administration in potentially veto this whole thing. So I don't want to take any chance that this gets vetoed on that. And I haven't had the opportunity and probably not in the best position right now to ask the administration about that.
Oh, please, why don't you put it in there?
I can just ask Kenny if it's okay.
Okay.
That's.
I understand that. I just was curious and I appreciate hearing the background of it.
And my understanding from past testimony is that this is not something that's being charged generally hardly ever anymore. So, but I mean, I could, send Kenny to the administration and see if they would be fine with it.
Kenny is kind of happy with this right now. I wouldn't blow it.
Okay. So there.
I mean, it's, you guys do what you want, but I'm just saying.
That right there was why. But not necessarily just Ken, but it could be others.
I have other things to play. Let that one go.
Switching gears.
In all the time that I've been in here, I've never raised my hand fully until this. Feels really good.
It's not because of
It's
the
usually
level of your.
I think she tried to hit me.
That's what I was thinking too.
That's out of reach. I was just wondering if, I appreciate this Vermont Sensing Commission report being added in. I was wondering if you know, or Karen, if you know, if anyone knows off the top of their head, if this date aligns well, the date of the report aligns well with the next step in designing the women's facility. Because the amount, when we've heard a lot about bed count in the design and knowing a little, we have a clearer idea of what direction we're headed with fail in Vermont that may impact that number.
The thing is that we are not going to get this report back before then, just knowing the Sentencing Commission and what we're already piling on there.
Maybe the women,
I think the timing could work out well. It's like we're already wrapped up with where they're at now, and there's going to be a pause between now and January. So the fact that this is happening before we start back up session, I think that makes sense.
Okay, I couldn't quite remember the timeline for next steps, but I know that that's
Great,
it'll
thanks.
be a consideration.
Thank you, Karen. Thank you for knowing that information. So we won't vote on it right now because we are going to move, but we will vote either depending on how long this next bit takes, we'll either vote before or after we're on the floor at 3:00.
Why would you vote now where I'll probably vote yes? And then you got to vote? Finally, I'm agreeing.
You always like a little extra time.
I sure do. But this doesn't seem to be like the others.
You look hard enough, you'll probably find something else.
that stuff, Martin.
All right, so we're going to move on to this.
There's a.
Oh, is there?
Editors just finished. I was anticipating this, so I had them start working on it early this morning, so that you will have a clean copy. So I'll send it to Panina just so in case people want to see, because this one still has the highlights, but you'll have a clean copy as well.
I just wanted to. One my students.
Well, excellent. We'll definitely do that in just 1 second.
All right.
So, yes, so we're going to move on to 89, but please introduce everybody else sitting here.
So Eliza was sitting next to Rachel and Jen.
Hello, Eliza.
Is taking nonprofits and social change, which we had our last class. And she's interning with Rachel at Legal Aid.
Oh, awesome.
And she's a best and bright UVM student, and it's exciting to see her here in person.
I'm watching you from afar.
Welcome to the committee.
Thank you.
Okay, so we are going to start with Rachel Seaman from the Disability Law Project on there's actually, hate to say, but there's we don't have to look at
Is there a new version or just the one from yesterday?
There is a new version, but the one that's 5 I don't know if you had the
I
chance
was
to
able to
listen.
watch you remotely this morning. So
Okay,
I pretty good
okay.
sense of what you were speaking.
Okay, all right.
But that makes one of us.
This morning.
Seriously. To a new. How can you have this thing here?
Is that what you needed, Joe?
Oh,
Yes, it was very helpful. Thank you. Yeah, so we put that into the miscellaneous bill. So we exempted credit card debt as defined by the Statutes Act. Medical debt is defined by, there's some medical debt.
There's a medical statute. Great.
Yeah, cool, thanks for that.
That worked out so quickly.
Yeah, me too. That was my worry, was just it getting taken advantage of. Being able to exempt that, make sure take advantage of, makes sense.
Thank you. I appreciate that.
It was painful.
So thank you for being here, Rachel. Identify yourself for the record and proceed and let us know where you are with the
Absolutely.
latest of S89.
So for the record, my name is Rachel Seelig. I'm the director of the Disability Law Project at Vermont Legal Aid, as well as our staff attorney for government relations. I had a chance to take a look at the significant changes to S89 and listen to what you all were talking about this morning. So I thought I'd just kind of run through a few different pieces that I noticed that worthy of some conversation.
Great, thank you.
When you were talking about the intent language this morning, I heard a question about this allowing for multiple forensic facilities rather than just one. Given that we have significant concerns about the need for a forensic facility for people with IBD in the first place, that was of concern to me, especially because overall in our mental health and developmental services systems, we think that it is better to invest in community-based care. Mr. Scherer also identified some concerns about the intent language, that it contains intent to do something before the work group has made a recommendation around people with IBD, and that was also a concern to me. So I would concur with him on.
Say that one again, I'm sorry.
So there's some intent language about this being intended to be a facility that will serve people with intellectual or developmental disabilities. But the work group hasn't actually met yet to assess whether this is a facility that is needed for that population. And so I'm a little concerned about saying we intend to move forward with this for this population. It seems like it draws the conclusion before we are able to get to work in the working.
Right. And I understand that. And I think, as I explained it, I think that at least, well, not everybody in this committee, obviously, but just from the conversation here, from healthcare and such, I think there seems to be a real need if an individual's choice is being in prison versus in a forensic facility, that would make sense. So having said that, that's why as I explained this morning, we kind of put this break on this or stopgap, I'm not sure what I should call it, that one of the first issues that the committee is to look at way back in the page 6 is the extent to which a forensic facility addresses any unmet needs or gaps. So, I mean, it's asking that question, and if it's not, then it doesn't proceed.
So the
I think we need to,
change if that was what the work group came back to you on.
Well, no, I think the intent is, it's just that this is what we intend for this working group. That we, I mean, I want.
Okay, I guess that's the clarity piece. Then that's helpful, Mr.
Well, here's where this is at least where I'm coming from. That what is the assumption going in, and how is that going to hopefully guide? But let's make sure that we make this decision. At least the testimony I've heard, I'm convinced that there probably is some very limited spot where this could work. Mm-hmm. And I think this intent language suggests that, but I want the work group to check that. And if the working group, if it comes back and says no, and, it still was the intent to look at it from that perspective that we, have, and this is, I think, very much AHS's perspective, but I do want to have that break. I want to have that stop there. Then I want to have that to be the first question. Do we really need this? Yeah. That makes sense? Or
it does. I do. I might suggest a little bit of a modification in the intent language then to be specific to the work group. It's the intent of the work group to do this, not necessarily the facility. All
right, thank you. Yeah, if we'll do that right after we talk because we're trying to get this.
I know, I understand. Yeah. Another piece that I heard in your conversation this morning, and I apologize, I may have misunderstood Stuart, who it looks like is on the screen, was that this would only be intended for people with intellectual disability and not the broader umbrella of people with developmental disability. That was the first I'd heard that, and wanted to just make sure the committee was aware of the way those two different terms work together. So developmental disability has a few different definitions. Most broadly, it's a disability that arises in the developmental period, which in federal law is up to age 22. In Vermont law, it's much narrower. It means either an intellectual disability or autism spectrum disorder, which occurred before age 18. Whereas intellectual disability is specifically is a subtype in developmental disability along with autism. That has to do with significantly sub-average cognitive functioning, at least 2 standard deviations below the mean on a norm-referenced intellectual test, which is generally an IQ of 70 or below, plus or minus a standard error measurement of 5. That's a lot to get through. So I was a little, I think that was the first time I'd heard that this would be specifically for folks with intellectual disability and not with autism who might be committed to Act 248. I'm not quite sure what the distinction there would be. I just wanted to flag that for you.
So should we have, is your view that?
I mean, my position is again that we don't need this.
Right.
But I do think if you're going to have it, I would want to understand why you would pick one part of that population as Vermont defines it and not the other.
So do you mind if I ask while we're on that question?
No, not at all.
Now to ask Stuart, who's appearing behind you. So Stuart, if you could weigh in on that question, I'd appreciate it.
Sure. The reason that I raised that was that under Act 248, as it currently stands, an individual must meet, in order to be a person in need of custody care and habilitation, the first prong of that test is that the person must have an intellectual disability. So if a person has autism spectrum disorder but does not have an intellectual disability, they would not be eligible for Act 248. Now, it's quite possible that an individual could have both an intellectual disability and the broader developmental disability, such as autism, as well as Rachel just pointed out, the IQ under 70, taking into account the standard of measurement and the adaptive skills that deviate from 2 standard deviations below the norm. So it's possible, but my only intent of bringing that up was that we're not talking about the entire population of individuals with developmental disabilities. To be eligible for Act 248, one must have an intellectual disability, which is much narrower.
There's a lot of co-occurrence, so I appreciate that, Stuart, because that's helpful to understand.
Okay.
All right, I'd like to keep moving through.
Yeah, thank you.
Sure.
So the exemption of certificate of need, again, this is a concern for us. There's a pretty well thought out process for when certificate of needs are appropriate. We have a state policy that the general welfare and protection of the lives, health, and property of the people of the state require that all new healthcare projects be offered or developed in a manner that avoids unnecessary duplication and contains or increases in the cost of delivering services, while at the same time maintaining and improving the quality of and access to healthcare services and promoting rational allocation of healthcare resources in the state, and that the need, cost, type, level, quality, and feasibility of providing any new healthcare project be subject to review and assessment prior to any offering or development.
So on all of that one,
Yes,
I'm going to make a note that you need to talk to Lori and
happily.
Alice.
Yes,
That one is not
not your jurisdiction. Yes.
a language. It didn't come from here.
Okay. So moving on from there to the working group. This is an awfully big working group, even with the reductions that I think you identified this morning. I do think that we should not kind of try and call this something other than what it is. In this bill right now, the language continues to call it a forensic level of care. I think we need to be honest that it's an institutional level of care.
And where are you seeing that?
That is, let me go back to the bill language here.
Forensic level care.
Line 6 on page 4. And I spotted it a couple other places as well.
All right, I'll just flag that to look at a little further. Yeah, go ahead.
So when that was brought up earlier this morning, and I think I didn't knock back, what, seven people or something like that. I'm with you on that, because it's like, aren't all the different people that are involved with this, aren't you going to have like a core group of people that is going to be, you're going to be answering to or listening to or whatever? We don't need all those people to go and get an answer.
It's not that I don't want a lot of stakeholders to be able to provide input here. I think stakeholder participation is really important.
Right.
When I think about this population, and when I came in and spoke about it last time, this is a very small group of people. I think, Stuart, you can correct me, I think we're at like 27 people in the whole state on Act 248. And that what we're talking about here is that the state has identified this as a need for like 2 or 3 of them.
Right.
If we have this large group, we can't talk about those people. I won't be able to, or my designee wouldn't be able to talk about those people without violating our obligation to keep their confidences, right, as their attorney. If this is us working directly with the department, who's the opposing counsel in those cases and knows all of that confidential information, we can actually be talking about the people rather than kind of the broader concept or philosophical question of whether we should have, institutional care for people with developmental disabilities again. So this may make it a little bit more challenging for us to have conversations about the specific problems that this is trying to solve.
So what's your suggestion on how to address that?
Well, I would want to make sure that even within this working group, that those of us who have that confidential information about the folks who are committed to Act 248, which is Vermont Legal Aid's Disability Law Project, Dale, and in particular the public safety specialist, would be able to meet to have conversations that can be kept in confidence without violating our ethical obligations.
So you're saying that just those three should be able to have part of the conversations,
Yeah.
or are you talking about extending protections to this working group, if that's even possible?
I don't think there's a way for that to be possible. So I think it would be that we would be able to meet kind of as a subgroup of this working group.
And I don't see any reason why
Is
we
it-
couldn't
okay.
do that from this.
I just wanted to flag that as like
Yeah, absolutely understand that concern.
Okay. Next concern, whether we start in September or July, I'm really worried about a November deadline for a report. If we start in July, we're going to come up against lots of people's vacation schedules, breaks, needs to take care of their kids. And we want to make sure we can do this work right and have these conversations. And so I'm just worried, I think in the version that you were kind of thinking about in terms of the working group last week, it was to give us all the way till November of 24 to finish the work. And instead, we're talking about, less than 6 months to tackle a really heady policy question and clinical need question.
True, but I don't think there's a lot. I mean, we're not going to go a whole year after. This is, if the working group comes out and we're not going to have a spot for intellectual disabled individuals, we definitely want the DMH to regroup and decide how they're going to proceed with the forensic facility. So we're meeting the January or July 24th. We can move it back later in the year, and particularly if we're having legislation as the end product, but not by much. I'm talking December, not.
So the other piece that I'll talk about just in terms of deadlines is that I wouldn't suggest having a group sunset as quickly as December, because you want the chair to be able to come back in and talk with all of you as the chair.
Easily fixed. Yep.
And I guess as I'm thinking out loud a little bit, having, read the draft this morning, listened to you all this morning, is that it sounds like what you're concerned about is there's that threshold question that this working group is going to need to address.
Right.
And if that turns out to be no, then that piece of the work could be finished pretty quickly. We do think this is actually an opportunity to do some updates of Act 248. There was some language that was originally in the bill that we had some concerns about, but that we are very happy to talk with Dale about in terms of bringing Act 248 kind of into the modern era. That maybe can't be finished that quickly, but would at least. So maybe there are kind of two deadlines for this working group. One is the question of, is this facility needed for people with IDD? And then the other are the additional tasks.
So, yeah, the first task is obviously a forensic facility, and we can extend the working group to July, let's say July 2024.
Yeah.
And the report back on, we can put it into early December. Having seen reports like this from others.
Yeah.
Yeah, we have that answered, and we are still working on
the others. Yeah.
Act 248.
Yeah, okay. So as long as that you're comfortable with that and we kind of know that's your intent, I won't ask for change.
This is what happened.
That's the reality. Okay.
Yeah, but I absolutely appreciate what you're saying, that's not the number, that's not the first order of priority. But it also could be done, like you say, if fairly early in the process, it's determined that forensic facility just is not the appropriate place.
Yeah.
Then they can use the rest of the time on the Act 248 modernization. So, all right, so go ahead, I'm sorry.
Couple other pieces here for you. One is that, and I apologize if I missed this, if these folks were cut out or not, but there is a provision that we would be able to appoint up to 2 folks who have experience with the criminal justice system or the civil commitment system. We actually did reach out to some folks to see if they wanted to provide their own lived experience in the legislature. It's a really challenging thing to ask people to come and talk about, much less participate in a work group about. Again, this is not because, I'm not raising this because we don't want engagement from people who have this lived experience, but I would be worried about that being a mandate and then struggling to find current or former clients who would want to fulfill that role.
So the next version will have something along the lines of they shall consult with these different entities.
Okay.
Should we be changing that to may, or should we just put some hedge language of shall to the extent possible? But I think that we kind of want.
Shall to the extent possible probably sounds to me like the most realistic option.
I've seen that kind of language with very similar issues that we're bringing up before.
And then the other thing that I really wanted to highlight is that I think there needs to be a role for input from the existing state program standing committee, which is also referred to as the DD standing committee. This is a board that is required by the Vermont DD Act to have input into the system of care for the developmental disability services system.
So and we'd add that to who has to be consulted with.
Yeah.
And it's the Developmental Disability Standing Committee?
State Program Standing Committee.
Okay, state. What is it? Disability?
It's specifically for developmental disabilities, yes.
I think it's referenced in number 8 on page 5. Line 13. No, it mentions the program. It doesn't mention what you're asking for. But lines 13 and 14 on page 5 of draft 5.
Somebody to be right. Yep, got it. Okay.
And let's see. In terms of the powers and duties, I certainly agree with the first power and duty of needing to determine if there is a need for this. In the second power and duty, sorry, I'm just trying to get to that page. The circumstances under which an individual committed to the custody could be placed in a forensic facility. I would change the specific circumstances to whether there are circumstances. Again, because when you use specific circumstances, you're drawing the conclusion that the facility is needed. In the third one, improvements to address concerns with the due process for individuals.
And we're going to have some language that's changing that, but go ahead.
Yeah, I would suggest changing this to amendments to Act 248's due process protections needed, whether or not the working group assesses any need for an institutional level of care for individuals with intellectual disability.
So say that again.
Yep. Amendments to Act 248, and I specifically had due process protections, but it could just be to Act 248 needed, whether or not the working group assesses any need for an institutional level of care for individuals with intellectual disability.
So there'd be improvements to address concerns with the due process.
Instead of that, instead of improvements to address concerns with the due process, just amendments to Act 248 needed, whether or not the working group assesses any need for an institutional level of care.
Do you mean that will be assessed, right? Whether or not, is it whether or not it's determined?
Whether or not it's determined that there's that need, yeah.
And I'd like to keep the words due process in there somewhere.
Yeah, I think so. And I don't know if you guys got the language. I was,
Not entirely.
if you
I
could.
can email it.
Yeah.
I was just about to ask. So the one thing is that I've been avoiding, maybe I shouldn't, Act 248 and actually saying what the title and chapter is instead. So is
I think that's fine. Yeah, I don't think we have to.
chapter 206, is that
I
right?
believe that's correct, yes. And then 4, 5, and 6, I don't have any problem with those charges. I do think more time beyond November would probably be appropriate, especially for 4 and 6. I think if you're looking for statutory changes, you probably want those in November or December, but determining if this is an ombudsman, a new ombudsman program, a DRVT program, or other investments and policies. Those probably aren't quite as much needing to hit that November 17th deadline.
Right. And again, we'll keep the working group open till July 1st, 2024, just with the understanding that that work might have to continue beyond that initial report where the focus really is the forensic facility issue.
So those are my suggestions for you on these changes. You know, as I said, it's our position this facility is not needed, but we are certainly happy to have conversations in this work group or elsewhere with the department on their concerns. We've started having those conversations already, and we're certainly open to more.
So you're open to changing your position, just like Dale is open to changing his position through this process, right? Right, Stuart?
Absolutely. We're
All
always
right.
open to discussion and change of mind.
Okay, thank you. I'm glad I heard that from various people. That's the important part.
Be the
All
legislative.
right, so you were going to provide a suggestion on the legislative intent and that language that we just talked about for
Yes,
for section 3, right? Is
that's
that
right.
okay?
Yep, I'll sit over here and finish my drafting for you.
I appreciate that. And we're good, we'll give it a little more time, December 15th, I think, because we'll be lined up to, we'll get in line for getting that. Well, maybe I'll put the bill request in right now. Or maybe we're just amending this. No, we're not going to be amending this. Anyway, we'll figure that part out. And, all right, good. Yeah, Joe.
Question. This morning we had some discussion about how, you mentioned a moment ago, how unwieldy the membership is.
Mm-hmm.
If you had to make some hard choices about who to take off this list, who would you be taking off this list?
Fortunately, I don't.
If you had to make some recommendations to a committee of the legislature.
I forgot to ask that question. That's absolutely what I was going to ask as well.
Yeah, okay, so running through this, let's see here. Membership. I think I heard you earlier today pull off the public guardianship program, but I think Stuart also mentioned the person who's going to have within Dale the most knowledge of the actual individuals is that public safety specialist. So I think, it goes to the concern I have about sharing confidential information about these folks in these conversations. I don't necessarily know that person, how much that person's going to be able to contribute without disclosing confidential information. So it doesn't necessarily mean they don't need to participate, but I want to identify that for you. I certainly think we need to be involved. The DD Council.
Before you move, that first one, I'm actually taking out of this next draft is not in there because there'll be a designee from Dale, and as we discussed this morning, they will
likely to be
going to more than one person who has expertise in different areas that they're working on. So
I do think, having the DD Council, which has folks with lived experience with developmental disabilities as well as family members, makes a lot of sense. Green Mountain Self-Advocates. I do think Vermont Care Partners, given that they are the ones who serve these folks in the community, are really important to the conversation. I'm not sure that the psychologist with experience conducting competency evaluations is necessary.
real quickly, I'm just going to, number 6, 7, and 8, I was moving to the consultation.
Consultation, all right. Yep, I think that makes a lot of sense.
And 13 and 14 as well would be in a consultation role.
What about 11 and 12?
We were keeping 10, 11, and 12. is there, I guess there's, well, because there needs to be, if it's proceeding, there needs to be coordination with the mental health component as well as Dale. So that's.
So that might be a reason to leave it at 11. I mean, I think the reality is that these are folks who are not in the custody of corrections, right? They've not been convicted of a crime.
Right. So
That's part of getting onto Act 248 is you can't be convicted, right? And so I'm not sure that the role of corrections is really appropriate here.
So we'll put them into consultation unless I'm hearing different from Stuart, who just appeared behind you. And I will go ahead, Stuart, and recognize to.
Thank you. Stuart Scher, General Counsel at Dale. I think that it's important for corrections to be at the table here, because while Rachel's correct that individuals who would not be in DOC custody once they are placed in Act 248, there are individuals who are in corrections custody at this point because they cannot find a placement in the community. So there is an impact on corrections as a result of not having a solution other than a community-based solution.
So would that be information that could be obtained through consultation as opposed to them being part of that group where they're there presumably all the time, when it seems like that's one part you would definitely want to hear about?
Sure. Yeah, I do think it's important for them to be consulted. It's probably not critical that they be members of the working group. So
it seems like the detail work is not going to be involving corrections, but there's definitely important information. So I think we should add them to the consultation role as well.
And then I think the last people on the list, because I think you've already identified pulling out 13 and 14, are you members of the legislature. I don't think I can recommend taking you out.
Well, you can, and it may be wise, but I'm putting those folks there just to crack the whip and make sure we get some things resolved one way or another. I saw how the forensic working group worked without legislators last time, right? So
no, I understand that. My experience is primarily with the Special Education Advisory Panel, which for many, many years required a senator and a member of the House on it, and they were never able to attend meetings, and so the group couldn't get to quorum.
We'll find somebody who can be assigned who actually can.
Okay, we had to change the statute in order to pull your colleagues off because we really needed to get to quorum to do the work. So
I understood.
Having learned from that experience, I needed to flag the question.
No, I thank you. I'd like some pushback on that.
Yes.
All right.
Any other questions?
Yeah, other questions? All right, thank you so much for being here. Thank you for the input, very helpful.
Absolutely.
So Matt Valerio, you can join us and weigh in. Tell us how much you like working groups.
The last few have been interesting.
Yeah, that's true.
Good. Actually, I'm Matt Valerio. I'm Vermont Defender General. I was I didn't see this until just a few minutes ago. Doesn't look anything like what I thought I was going to talk about. But I'm nimble if nothing else. So
we only got this at 8:20 this morning anyway, because we've been working hard to keep it moving.
11. This says 11:32 p.m. I was not focusing on this at that time yesterday. I guarantee that. As I've testified before, we see folks with mental illness, with developmental disabilities, and the like in the criminal justice system all the time. And it is apparent that there are some who would be appropriate for a forensic facility. We don't have any place for it. We used to have a place. I've said before, it got washed away. We don't have a place for it. And, I think that some of the folks, as a result of their illness or disability, they end up getting stuck in corrections, which is not a good place for people to get stuck, especially if you have mental illness or or a disability. And they become targets. They become victims of other inmates, of corrections officers, of in general a system that is not designed to focus on anything that they are struggling with. And so I do not change my position on whether or not we need a forensic facility to handle these folks. I don't know. There are details that may have to be worked out regarding, and I thought rulemaking would do that, the various subgroups that would be qualified to go into the facility. But, I was on that S3 study committee for 2+ years. And it was a very large group, in my view, overly inclusive and detrimental to coming to any sort of result or consensus. I see potentially the same kind of thing happening here. And I would, but.
Just making clear, we are moving several of these individuals to must be consulted as opposed to in the working group to narrow the actual people at the table.
That's fine. It's still a pretty big group.
Yes.
I mean.
It's not 29, it's only like 11, so.
Right. 11's a healthy group for a study group anyway.
Yeah.
29 is.
Impossible.
Yeah. I mean, it makes it very difficult to try to get anything done.
That's the whole Senate. Not at all. I'm just saying potential confusion.
Maybe that should be the group. Say we comprised of the Senate of the state of Vermont. I think at some point here, you folks just need to make a decision about what you want to do. I don't know that another study group is going to get you there. And maybe it's the kind of thing where the bill should just be held till the next session and you should continue working on it and flesh it out as opposed to study it some more. It's the first year of the biennium, and if you need more testimony, bring in the people and talk to them and make a decision. I think that, sometimes these study groups are good because they bring out information that you haven't had. We've been talking about this for 3 years now. And I know that during the pandemic, it was a difficult situation. It's not clearly what we're doing now. It's just so much better than anything we had to deal with during that time. But from my perspective, we have clients out there who are aggrieved by being in the conditions they're in the Department of Corrections, who are suffering from mental illness, who are suffering from these disabilities that would be subject to, have the opportunity in some ways to be in a therapeutic facility that the Department of Corrections doesn't have the wherewithal or frankly interest in handling. And that's been apparent to me. It's the wrong place to deal with mentally ill and developmentally disabled and intellectually disabled people. So, if this ends up being what it is, or after conference committee, well, so be it. We'll do whatever we need to do. But I think that it's time to fish or cut bait pretty soon. Meaning, either to me, doesn't necessarily have to be this year. In 23, but do it next year. And bring in, if you have questions about stuff, you need more detail or more information, just do that. But get it to the point where you can finally make a decision and take a vote.
Right.
That's my opinion.
Yep. No, I appreciate that. And I think that's what this is designed to do. And it's designed to keep to the effective date of July of 2024. So we feel Yeah, we could just take up, yeah, that was an option, just take up the language again starting in January, but I think that work can be done in the interim, and that's what this tries to do.
And, the focus here is obviously on the PD group as opposed to the mentally ill.
We think as it stands right now, the language that we had for the mental health group is in pretty good shape. So, and we're expecting that, that's going to be somewhat of a jumping off point is the language that we've been working on for the past, between the Senate and us the past few months. So.
So if there were any questions, I'd be happy to take them, but.
Any questions for Matt? Not seeing any. I appreciate you being here and for your, what'd you say, flexibility? No, you said your nimbleness. Thank you for the nimbleness as well.
No problem.
Matt, did you say what, as far as the working group goes, did you throw a number out there you thought was a good?
No, it's just don't make them too big because they just don't work.
Box it down. Box it down.
Yeah, for sure. Thank you.
Thank you.
Thank you.
And Susan, thank you so much for being here. If you could identify yourself for the record and proceed, I really appreciate it.
Hi, good afternoon. For the record, Susan Aronoff. I do the policy work for Vermont's Developmental Disabilities Council. And I want to thank you very much for the invitation. And I just want to say I've been following you guys since 8:30 this morning. It's a very dynamic process. And I'll admit to being a little bit confused. But I just wanted to kind of go through the most recent draft with some specific concerns and then just leave you with some general thoughts. So my biggest concern about the most recent draft is kind of the disconnect, the way I read the legislative intent and the charge of the committee, where in the legislative intent sections, like around 13, 14, 15, it seems like it's a foregone conclusion. So as a backup, in our neck of the woods, I'm a lawyer in recovery, learning to write in plain language. And one thing I've been learning about plain language is to try to put one concept per sentence. Now, I don't envy legislative drafters, and poor Katie, she was doing this at 11:30 last night, but I think that sentence where it says, the work of the General Assembly is going to guide the departments and also guide the working group that's established to section 6. I think that needs to be broken up, because when I read that sentence, you're basically telling the working group, hey, you guys are going to be recommending procedures and criteria to commit people with developmental or intellectual disabilities to a forensic facility. So that seems like you kind of jumped the gun of what you're asking the committee to do, which is to recommend, do we need an institutional level of care in our system? So I think this has gotten some attention, but I haven't heard any resolution to it. So I would just like to say, strike the section about the working group established and in that sentence, and just have this guide the departments in going forward. So that would be my wish, because the working group, you give the working group its orders in the working group section.
I'm hearing you, I'm hearing Rachel, I'm hearing others that offline have commented on this, that we need to work on that intent section.
Well, I would like to say, and I want to give as much support and appreciation and commendation to Karen Barber and Stuart Scher and Jared and some of the other people who've been working on this. Karen has tried her hardest to bring people together. This was really focused, the working group was really focused on people labeled with psychiatric disabilities. I was the lone representative, and I was glad to be there for people with developmental disabilities. I think the message that everyone has heard loudly and clearly and received, thank you, is the basic nothing about us without us. And what I really appreciate between House Human Services and Vermont Care Partners and other people kind of opening the door back up to say, let's talk about the needs of our developmental disability system, because in this Vermont State House and in Vermont in general, the mental health system gets a lot of attention. The developmental disability system, not so much. And yet we get tagged along, and sort of brought along. And people with intellectual or developmental disabilities are very different, particularly in this context, because the whole idea of restoring someone to competency, or so maybe they can stand trial, that just does not apply when you're talking about an intellectual. There's no medication regimen, there's no treatment regimen that's going to change someone's status as a person with an intellectual disability. It's just different. So to have everyone in the same bucket, have everyone in the same treatment bucket, I got to say, we haven't discussed in this committee, this isn't the right committee to discuss it, the huge overlap between people with developmental disabilities and psychiatric needs. Those needs are going really unmet. So I'm not necessarily opposed to having people with developmental disabilities and people with psychiatric disabilities in the same facility getting, treatment and services, because I think there's a large cohort of people with co-occurring. But we're not talking about co-occurring people here. We could be having people with intellectual disabilities who don't have psychiatric disabilities, who who communicate differently, who have a lot of different needs that may or may not be able to be met in the psychiatric hospital, in this setting. Now what I understand, listening into the Corrections and Institutions Committee, is the Agency of Human Services now isn't entirely sure that this is going to be the location for the place. So anyway, I think that the main comments I want to make is I think it would be great to have a committee that's really focused on the needs of the people with intellectual and developmental disabilities, and even clearing up that issue. I think it deserves a larger conversation in a different place. I think that one of the things that's happening here in Vermont, and what I really don't want to leave this room without saying, because all of you will be voting on the budget, is these are chickens that have been coming home to roost. And to Representative Gosselin's point, these are issues. These are not new issues. And these issues predate the pandemic. And what has happened in Vermont's home and community-based system of services, where people with developmental disabilities, people with brain injuries, people with certain psychiatric disabilities get their care in the community, that workforce has just been decimated. Like 30% of developmental disability positions right now are vacant. And so it's sort of no wonder to me that we're having, what did the administration ask for in the budget? It did not ask for rate increases for the care providers for people with developmental disabilities. They asked for new buckets of money to serve a couple of individuals in this high need public safety situation. And so that's what's happening now in our Agency of Human Services, is that the people who are breaking out in crisis are getting a lot of attention and resources. And the people who are at home being taken care of by their family caregivers or by shared living providers who have not seen increases, all of a sudden these people became 24/7 caregivers during the pandemic. Their services have not been restored. And that's what I like about the focus of this committee, is to look at what's going on in our community-based system that's making it so that 30 years ago we closed Brandon. In 30 years since we closed Brandon, why is this need coming out now? Could it be because this is as good as it's going to get in the legislature this year? It seems our home and community-based system is going to get a 5% rate increase. That's not even inflation. I don't know how we expect our community-based agencies to take care of the people the state is responsible for providing services to without increasing these wages. So then to go ahead and to put more people in institutional-like settings because we haven't done what we promised we would do 30 years ago when we closed Brandon, seems like we're really punishing the people and the families who we were supposed to be serving and have not been over these last 30 years. And there are some really simple things to do in terms of like improving the rates and improving the resources of our designated specialized services agencies to that point of the governor having put in his recommended budget, some pots of money in the developmental services section to serve people with these public safety needs. I think the main message for the Vermont Developmental Disabilities Council is that we need the resources so that everyone in the community can get the individualized plans of care that they are entitled to under federal and state law, and that just has not been happening. People have been told, approved budgets for like 40 hours of community services a week, and maybe they get one. Nursing care services, 60 hours a week, maybe they get one, if any. So I think to take a START system and then invest in the institutional type of care, it's just regressive. And hopefully this committee, we look forward to working with Stuart, with Dale, with anyone else to come up with a stronger community system. And then if the community recommends an institutional level of care, then we want to be there to work on appropriate guardrails and what's the oversight and how much time can someone stay in. Statistically, it is known that people with intellectual disabilities and developmental disabilities spend longer time in forensic facilities than they would have if they had been convicted of the crimes with which they have been charged. And so a lot of times people will be charged with misdemeanors, public nuisance, things of that nature, and then they end up in the forensic system and they don't get out. And part of why they don't get out is because the services that are needed to support people in the community aren't there. So I would hate to see Vermont end up with a system where people get in and they can't get out. So I'm happy to answer questions. And one thing I want to say is I noticed that Secretary Samuelson from the Agency of Human Services was here this morning. Our office, our council is located in the Agency of Human Services. We've been trying to have conversations we're supposed to be having with the Agency of Human Services about new quality measures. They're under a plan of correction. They're under a plan of correction in the home and community-based system, and they're under a mandate to have new quality measures. We've been trying to be part of that conversation. We welcome all opportunities possible to work with the Agency of Human Services to improve the quality of the service system for people with disabilities.
So questions. I guess the one question I asked, I don't know if you heard that we're moving various folks to the consultation. Are we missing anybody else that we should specifically set out for consultation? So we have, if you're looking at the draft, we've number 6, 7, 8, 12, 13, 14 to be consulted with, but.
So here's this experience that I have having had worked in the Department of Disabilities, Aging, and Independent Living on a healthcare reform grant, and having sat on committees with people from the departments. This is not going to be a popular view, but I would really recommend adding someone from the Agency of Human Services central office or the policy office, because in my experience, and Stuart can correct me if I'm wrong, the people at the department level, I hear from them things like what I hear from middle managers, which is we have all the responsibility and none of the authority. So I think sometimes people at our departments don't necessarily agree with some of these decisions, but they are an agency of one, and the decisions are made at the AHS central office. And if the AHS central office wants a forensic facility and wants to speak in support of it, I think they should be at the table. Because otherwise the departments are kind of left in the middle.
Interesting point.
I've been in those.
Oh yeah, no, we have too.
Yeah.
So, yeah, but whether somebody like that would be consulted with or a member and I see Stuart has shown up to weigh in on that one, so I will recognize Stuart.
Thank you, Mr. Chair. I'm hesitant to say that we shouldn't have another viewpoint from the Agency of Human Services. However, I think that an individual from the agency itself could be listed in a consultative role. I'm really concerned about expanding this any further than what's currently on the page. And that would apply equally to the recommendation that Ms. Seelig made about adding the State Program Standing Committee. I think many of the individuals represented from other organizations are members of the State Program Standing Committee. And I think those viewpoints will be adequately addressed without the need to add more than 11 members to this group, which is already at a level that we remain concerned may be too great as it is. So as much as it may benefit the group to have direct communication from the Agency of Human Services, we as the Department of Disabilities, Aging and Independent Living, Department of Mental Health, Corrections, if they remain on the working group, have access to the Secretary's office and can certainly share those viewpoints with the group. So I don't think that that's needed, nor do I think that any additional membership is required.
And in closing, I did just want to address one thing that had come up in institutions that might be worthwhile adding to the charge of the study group, or just some piece of legislative research that could probably be done. When I testified last, I indicated that, after I had taught mental health law, master's level classes for a lot of years, it just became clear to me that in the 50 states, we have 50 different systems of caring for people with disabilities who end up in state institutional care. I think right now we're maybe one of 2 states that does not have an official forensic facility. The majority of states have their forensic facilities and their forensic care for people in the criminal justice process within their departments of public safety and departments of corrections. And that's for people from arrest to acquittal to insanity pleas. It's just that if someone is taken into custody by a state entity because of a public safety issue, not because of a treatment issue or like a human service lack of housing issue, that's the track that the majority of our states have gone down. And then disability advocates over the years try to force correctional entities to provide services to people with disabilities safely and humanely, because people with disabilities commit crimes and end up in corrections and should have reasonable accommodations and access to every facilities. New Hampshire just had, I believe, a death in their forensic facility, psychiatric care hospital, which is in their Department of Corrections. What I think has not happened and won't happen in this work group is I don't think there's been a credible survey of what is happening in the other states. So I used to do that through my graduate students, but I really don't know that anyone in Vermont who cares about this really, and I include our department people because they just don't, we've had, no one there has been able to have the luxury of a research project. But I will say, looking at the 29-page draft, the 9-page draft, this isn't the best legislative language for forensic facility for people with psychiatric disabilities or developmental disabilities that's out there that's possible to put together. It just isn't. The location isn't. We're not choosing a location based on the treatment needs. We're choosing a location based on the beds that we're not going to be able to get paid for. So just even starting there, if we want a forensic facility, let's start at the drawing board and decide what would be a good forensic facility. Now it sounds like this is going to be a stopgap thing, and we've seen how well stopgaps have worked in Vermont.
I absolutely appreciate everything you just said, and am a bit stuck as far as how to get there. And perhaps as we continue to consider a new Department of Corrections facility, this needs to be part of that conversation. So part of it is, the facility needs, and if we are going to be building new facilities, this kind of thing should be taken into account. But that's pretty big change to move from one agency to another, and but even that makes a lot of sense to me.
Except strangely in Vermont, we have this agency of human services that includes our
Department. So they are the same agency.
Public safety is elsewhere. It's
know.
very confusing.
Yes,
Anyway,
absolutely can agree on that one.
so anyway, thank you for the.
Appreciate it. Appreciate it. So we'll hear from Tim Leaders-Dumont, who is filling in for Jared Bianchi. If you have any input on draft number 5.1 on S89, Tim, would appreciate hearing from you.
Thank you, Tim Leaders-Dumont, Department of State Sheriffs, and I am just looking through it now a little bit in full disclosure. And I don't think I have much to say without sort of further surveying some of the field statewide. I want to echo what I've been hearing from some of the witnesses about treating individuals as the full person with co-occurring. I think matters in life are not as simple as sort of this type of person, that type of person. So I appreciate that conversation. The slight hesitation in my voice is just about further study. I think you've heard about that, and also the ability for any group to function as a large group. As you all know, as elected members, it can sometimes be a challenge. But I appreciate this new draft's direction to set forth treating people as one person, as opposed to different things that they may or could experience on the personal, medical, psychological, et cetera, type of level. With that, I really don't have much else to offer. Certainly, we would have appreciated the ability to have a facility as soon as possible for all of the reasons that you know about. So we just want to continue that urgency moving forward. And I'm sure I can try to convince Jared to be a part of another summer group that he obviously the last many months working with many of the folks who you've already heard from.
Great, I appreciate that. Any questions at this point for Tim? All right, I think this probably is about the extent of the testimony we're going to get on this, but we have some issues we're going to look at. So I actually wonder if Katie, if you can actually join us, we can kind of walk through what we've been hearing and give you some more direction. Although I haven't looked at, we based this on draft number 5.1, and but I explained to folks mainly what we were doing as far as moving patient, et cetera. But let's kind of walk through so we can. So I have now, I think at least 4 different possibilities for legislative intent. I have 5.1, unless the new draft is 6.1.
The new draft is 6.1.
Yeah, so I assume that unless the new draft 6.1 is along the same lines of the legislative, that didn't change much from our legislative intent.
There's a bit of change. There's a restructure, and there's some language that DMH submitted that.
Right. So there's the DMH. There's what we just you sent me from Corrections and Institutions.
Right.
And then Rachel Seelig had sent a suggestion. So
okay,
we don't have to resolve that right here and here because we probably want to compare those 3. But I think one of the main points is moving away from, and this was my fault, this is what I wanted in here, of course, but it was that like this presumption that we are going to have a forensic facility for this group of individuals. That's kind of how the legislative intent reads. So we need to be more neutral as far as the outcome of that whole process.
in the legislative intent section.
Yeah. So, and I just haven't had a chance to look at the new draft, the corrections or Rachel's, which I will email to you and we can talk about that.
Okay.
So moving ahead, what the new stuff we've heard, and there's not a whole bunch of new things, I don't think. We want to make sure that the State Program Standing Committee for Developmental Services is one of the entities that is going to be consulted with. It was the entity that would name a family member of an individual with developmental
Okay.
intellectual disability. We want that family member, but we also want to include for that consultation part.
Okay.
And we're also going to move the Commissioner of Corrections to the consultation part.
Okay.
And
Okay.
and also in that consultation part, we want I'm assuming this isn't in the language, but we were talking about that they shall consult. We want to put a little hedge in there, like shall to the extent possible, because it may be difficult to find individuals with intellectual disabilities who have had experience in the criminal justice system. So
Okay.
I don't know that I have the exact language for this, but this is the language you are already going to be changing. So, no, I'm sorry, it's not. I'm looking at the language I'm looking at 5.1 draft. It's lines 13 to 14, the specific circumstances under which an individual committed to the custody, change along the lines of whether there are circumstances under which.
Maybe the specific circumstances under which an individual committed to the custody of Dale could be placed in a forensic facility if the the study group determines that you sort of like make it conditional on one, basically make it conditional on the outcome of one.
I think either way, well, yeah, you know what we're kind of after with that, okay?
Yeah. If the working group determines there's a need for a forensic facility or for these individuals to receive programming.
Yeah.
Forensic facility.
And I think same kind of hedging language in the next one that discusses due process. And I think I do have a language suggestion, but Rachel, although I thought it was a little long, but we can look at that as well.
I just put the word any in. I don't know if that solves it. Improvements to address concerns with any due process, or is that what I had? With any due process concerns.
No, I can send, I'm going to send it to Katie.
Address concerns. Okay.
So you can note that there I have some language suggestion from Rachel Seelig as well. And we can work on that a little bit further. Let me see what else I had. Changing the report due date to December 15th. On
December 15th?
Yeah, December.
Okay.
So the big question is, if we're involved in working on legislation, if we have it in December 15th, if I put in a bill request like next week, will it be in line for when we get that legislative language? That's the only thing, is it's a matter of if that's going to be.
I think that'll be tight.
Okay.
And I don't know off the top of my head.
Of course.
The dates are right in front of me, but I know in the second year of the biennium, the request and the introduction deadline are much earlier. So that might set you up for having 2 weeks to finish your work on that.
So is it, it is kind of the end of the year.
Because I think and I'm getting the Senate and the House confused, but you can work on it and then you have to have an approval, a date by which you can't make changes, but you can still get co-sponsors when you're back in the building.
Let's say December 1st then. I mean, we're giving them a little bit more time, not a whole lot since there's Thanksgiving in there, but.
Okay.
And for the working group shall cease to exist, we want to extend that to July 1st, 2024. The concept there is that report that comes in on December 1st may at that point just deal with the forensic, and we still have like other things we want them to do, like give us input on how to modernize Act 248 process.
Okay.
And we've not going to specify that in here. I think that's kind of to be understood. That the forensic unit's going to be the priority.
Are you going to, would you like to make a corresponding change to the number of meetings in light of?
Oh, do you have a number of meetings? How many meetings do you have?
Be applying for 10 meetings.
Oh, I didn't notice that you've done that.
We have to look at the definition of forensic facilities.
Yeah. Sure.
Okay, great. Well,
Let's pick a number out of the air because it's going to be what, I think you can keep 10.
okay.
And if there's more meetings after that, we will probably be in session and being paid anyway.
Okay, it's not just legislators though, it's,
Oh, right, the other folks.
yeah.
So,
Oh, I should add legislative compensation language though.
so if we're, so the representatives, so we have the representatives from Disability Law Project, Developmental Disabilities, Green Mountain Self Advocates, Vermont Care Partners. Aren't those all paid, presumably positions? That wouldn't, I mean, because we've taken out like the, the family members and individuals are just to be consulted with. I don't think we're in a position to
The one that really might not be is DMSA. They may have a self-advocate who's not.
GMS, right. Yeah, it's just that by the time we get to the, if this is extended to July 1st, a good part of that is when legislators are actually paid employees. So, well, I'm not sure how to handle that. If we have one individual who we may want to keep on having, but I don't want to ask appropriations for 14 meetings for legislators when it's really only 10.
Yeah,
Let's put 14 and see what they do to it.
okay.
See if we get them on a nice, kind day. So, all right, the other question I have, and this came from Teresa, and I actually started an email and didn't quite get around to sending it to you, but the definition section at the end, are we being presumptuous in H1B? Is that another thing that we're kind of presuming that it's going to be a forensic facility for that, or is that not?
Actually, I know there was a desire at some point for there to be a definition of forensic facility. So I took what we had been working with in the bill.
Is it possible to have it not connected to the commitment processes, or is it?
I mean, it's your definition. You can have.
Well, that's true. I guess I'll ask Richard, you didn't mention that as a problem. Is that a problem if we keep that
I
there?
did, but I should have. I do think it needs to come out until the work group makes its recommendation. And then at that point, if it does recommend, then you can amend your definition
Right.
in statute.
Yeah, I think so. I mean, I think it gives us enough of a definition in 1A to be proceeding, and we can change it or no.
Okay.
You thinking, or do we need the definition at all?
Well, maybe you don't need a definition and you're just referring to something generally. I wouldn't keep 1A and not 1B. I would probably make them both vague if that was where you were going, and just talk about individuals who are charged with a crime for which violence was a factor. I don't, not competent to stand trials, more use broader language. And
Yeah, I think that we should have that. Yeah, and just broader without the specifics on A and B. Thank you.
And I know you had said certificate of need is not our committee.
I did not. I mean, I did. It's
Yes.
not. It is not.
So it does seem like that's going to be tricky. It's going to be tricky if we don't necessarily know. I mean, we know there are a lot of needs. We're just not sure which needs will be met through the ultimate project, but that is not our headache.
That is not our headache. I'm going to make sure that, who raised it in testimony?
Rachel, and she said,
And
yeah.
you've already,
Upstairs.
you're going to go talk to Lori, right?
Yeah,
But
that could change,
yeah.
possibly.
And we do have some language that, from corrections, and with the caveat that I mentioned as far as the legislative intent, that we'll ask ChatGPT to take those 3 or 4 different legislative intents and write it as an ode.
Oh, nice.
You think that work? So we can put the other language in and then figure, they have a new section, language to the section 4. So I would put that one in. I,
Put section 4 in.
yeah, that you emailed to me, that was House Corrections and Institutions. We haven't looked at it yet, but it's their thing.
Okay.
But I know that they had some suggestion for the intent, but we need to reconcile our three different
Sure.
options.
Okay. I have a question.
Please.
The email of changes you were looking for removed developmental or in section 6, but only some of the time. And I wanted to make sure that was
That was also part of the
intentional.
email that I started sending.
Oh, okay.
Because I have witnesses also.
Yeah.
Yeah, no, it makes sense.
To be consistent.
Yes.
Okay,
Yes.
great, thank you.
Yes, thank you. Anything else that I'm missing that folks can recall? So I guess that'll be the next rendition that we look at, and I put on optimistically voting today, and that's not going to happen. So tomorrow morning, first thing, we're going to try to vote.
Okay.
So I'm getting you my input earlier than 8 o'clock today.
Great. Much appreciated.
Sorry about yesterday. ChatGPT only works so fast. I think that's it. Are we good?
And you did mention, you may have mentioned just adding the judiciary committees to both.
Was that one I mentioned earlier? Or? Yeah, that was this morning stuff.
This morning, I caught it already.
Yeah. Section 4.
Yeah.
Section 5.
Yeah. I gave the input from this morning.
That was 89, right?
To Katie, so.
Yeah, it's still on.
That was, yeah.
That's it. So thank you very much. I was going to actually skip floor to do this with you, and now I have to go to floor.
My apologies.
That's fine. All right, we'll adjourn. We're going to meet right after the floor to vote on S33 and to look at S36, the Senate's changes. And at some point, I can catch up with you, Katie, on that intent language if you
Sure.
want some more input on that.
Okay.
Good? Thank you very much. All right, so we'll adjourn until